thank you very much for this opportunity to talk about this teaching and learning project. And this presentation is actually looking at how inquiry-oriented learning links with flipped learning. Because the presentation deals with one component of a project that myself and two other teachers in the Faculty of Law, Jeff Holland and Angela Dwyer, conducted as part of a Vice-Chancellor's Teaching and Learning grant. And if we have a look at the slide up there, you'll see that there are many similarities between flipped learning and inquiry-oriented learning. So, for example, IRIL is an activity-intensive approach to learning that is strongly student-centred, and in a similar manner, flipped learning encourages students to prepare materials before class, allowing class time to be more interactive, so students can engage in activities that develop skills. And if I wanted to know what IRL is, I go to Guru. So I found a report that Les has prepared as part of his, was it the OLT? Was it the OLT at that stage? Yeah. And you can see what the elements of it are up there on the slide. But essentially what IRL is, it's a system of learning that encourages students to work on challenging problems and questions in order to formulate their own conclusions. So, rather than telling and showing, what we're doing is actually involving the students. And I think that's something that can be taken across lots of different subjects. So, the project. The Flipped Class project was designed to run across 3 subjects taught by the Faculty of Law, and in first semester it ran in Environmental Law and Environmental Law and Science, and in the current semester it's running in Animal Law, and the project that I'm going to be talking about is the first 2 subjects because that one's already finished. So Environmental Law, as the name suggests, is taught to law students, and Environmental Law and Science is taught to science students. Now, in the law faculty, there's already a tradition of flipping classes because students are expected to prepare for classes. They're given case studies and readings. And so what this project was designed to do was to extend this practice with these 4 objectives in mind. Very ambitious. The project operated within the existing framework of the subjects by making small adjustments to the assessment regime. The students in each class were asked to prepare a case study setting out the facts and decision with the specific brief of using technology in a way that the case study could be used as a learning tool by other students. The science students were asked to concentrate on the facts of the cases because very often environmental law cases are very much science-based, but they were asked to present them in a way that non-scientists could understand. And the law students were asked to concentrate on the law, presenting the law in a way that non-lawyers could understand. The presentations were made available to the students by UTS Online. So the presentations, for example, by the law students were made available both to the law students and the science students, and vice versa. And one of the ideas behind this project was to see whether we could actually get sufficient good quality materials that we could use permanently. In other words, we would be able, say, to use them on UTS Online, to encourage the students to use them, and then students would be able to prepare for class. The teachers would also be able to use it, but it's an incredibly time-consuming exercise, trawling the internet, YouTube, etc., trying to find interesting material. So one of the things that we thought was maybe to harness the students for this and see what happened. I'm going to give you an example of how this could work, and this comes from a case called Booth and Bosworth, and here I apologise to those of you that have already heard me talk about this case. It's probably my favourite case. And the case comes from the federal court and involves a decision on the legality of an electric grid that was built to protect a lychee plantation in Queensland from the spectacled flying fox. The spectacled flying fox originates from the wet tropic region, and the wet tropic region is adjacent to the lychee farm. The wet tropic region is also World Heritage listed. The problem here was that the lychee farmer had approval from the Queensland government to erect this electrical grid, but because the flying foxes originate from the World Heritage region, and that was World Heritage listed, that's something that the federal government's also interested in. Scientific evidence indicated that the electric grid could have wiped out the flying fox population within something like 3 or 4 years. It was quite incredible. Now, the students who presented this case actually went to a lot of trouble and found some really interesting stuff. They managed to find the original court documents, including this really interesting YouTube clip that was shot by the plaintiff. And here, I don't know whether this is going to work.
It should work.
Oh, good. Can you all see that? Okay. So I'm not going to show you the whole lot, obviously, but it was actually quite graphic. And at one stage, the students' court showed this, which I don't know if you can tell, but it's actually a young flying fox clinging to the body of its mother. It's quite horrendous. Anyway, so on one level, things like that really get the students interested. So on one level, the students would go through the case, development, understanding of statutory interpretation, etc. But if the students are able to grasp that quickly, you can actually use the case to get into much deeper issues. So what I did in this particular class was I divided the students into groups, and this is the sort of things they had to consider. One group looked at the extent of the Commonwealth's environmental lawmaking powers, not only as they exist, but what perhaps they should be, and what some of the difficulties might be. What were the pros and cons? So there were constitutional issues there. The second one was consideration of how Dr. Booth, who was a scientist, was in fact able to bring the case to court. Now, how did she get standing under the relevant legislation? How did she pay for the case? And, you're looking at a case that went all the way up to the federal court. And third, based on Dr. Booth's position, how would the students advise an activist who wanted to ensure standing in a future environmental case? And this last point is significant because it not only involves the students understanding what happened in Booth and Bosworth, but also it involves them taking those principles and being able to apply them in other cases. Well, what was the result? Well, first of all, the class discussion seemed to go quite well. What I found really interesting was that we went through all of that without a problem, but then when we were debriefing the class, they started getting into other things. And we did the case about the time the state government was announcing that they were going to be changing the environmental planning rules to make it easier for developments to go ahead. And one of the changes that they're proposing is that they're not going to allow objections to a lot of developments. So the students were actually able to look at that and say, well, how then do you get standing? So they're able to take some of the material that we looked at here and relate it to things that they've read in the media and ask questions. So I found that was a really very good learning exercise. So I ran the project for the semester, and these were my initial observations. The first one surprised me because I assumed that young people are very techno-savvy, much more than I am, but in fact they're not. And that I found, that came as quite a shock. A few of them did some really wonderful things, but most of them didn't. The other thing that I found surprising was that they actually, within their disciplines, they found it really difficult to communicate in a different way. So the lawyers, for example, found it very difficult to stop talking like lawyers, and the scientists found it really difficult to stop talking like scientists. So it wasn't that easy for them to prepare materials that lay people could understand. There were a couple of technical issues because some of the film clips wouldn't work on UTS Online, But on a positive note, the students looked like they really enjoyed it. So at the end of the project, we did what Peter Candelbinder was talking about as summative evaluations. We rolled out a survey, especially for the project. We did it through SurveyMonkey, and unfortunately, I think the students were surveyed out by that stage, so we didn't get enough responses to be able to generate, really nice statistics, but we did get some comments that we found useful. Among the law class, the students said that doing more than one presentation meant that some topics weren't covered to what they considered was a sufficient depth, and that there was a lot of content. That I found really interesting, because that's the first time I've had that kind of comment, that there was too much content in an elective subject. More specifically, with respect to the preparation of the learning materials, one comment was made that it would have been too time-consuming to do something different, so most students were limited to doing PowerPoints. So that defeated the whole purpose of asking the students to do it, because they were faced with the same practical problem as the teachers were, that is that they were time poor. The science students, they said that they, generally speaking, liked working in groups to prepare the learning materials and making their presentations. They also noted there was too much content, including one student referring to information overload with legislation. Comments from the survey specifically designed for the project include good fun, a great way to develop an understanding of legal and scientific concepts. I like the idea, good learning experience. The fact that it was done in groups meant that it allowed me to approach concepts in ways that I wouldn't have thought by myself. Some of the critiques included that they needed more guidance, etc., and the teaching team has taken that on board. So, reflections. The first one is that I was the course coordinator for both subjects, and it's really clear that I underestimated how introducing something that's inquiry-oriented would just change the dynamics so much. I didn't make huge changes. I thought leave things as they are and just introduce small changes. Interestingly, once the students started looking at a small part of the course in a lot of depth, there wasn't enough time to do everything else. I found that was just, that was quite extraordinary. Therefore, we need to think how we use the IRIL processes. Can they be added on to what's already there, or do we need to rethink the delivery of the subject? In particular, where you've got subjects that are content-driven, as I think many law subjects are, IRL is skills-driven, what do you do? My own personal view is that you need to start off with the skills and work from there, and yet I know that for many people producing content will be quite scary. After being inspired by this and looking at what some of Les's work, I'm working on a model to try and give this a bit more structure. What I find interesting, and this is still a work in progress, but what's interesting about this is that you start off with something that's teacher-led, and by the time you get to the bottom of it, what we're looking at is something that where the students are leading it. And just really briefly, just to tell you about the second part of the project, which is the animal law. With this one, there is no animal law casebook for this subject, because animal law is fairly cutting edge. There just isn't a casebook around. So part of the Vice-Chancellor's Teaching and Learning grant was to get some marking relief to help put together a casebook. So as part of the assessment, the students are doing 3 case notes each, and Jeff and I are marking them, and then we've got some external people from Voiceless, the RSPCA, and the Barristers Animal Welfare Panel that are going to help us edit them. And we're going to put them together in a casebook that will be made freely available to other educational institutions and NGOs. And although preparation of a casebook doesn't necessarily involve what might be considered a traditional IRL pathway, what we are doing is we're looking at the students making a contribution to the knowledge of animal law, and this transfer of knowledge to the wider community. In total, what we're trying to do is to give the students skills that they'll be able to take with them out into the workforce, and it shows the relevance of animal law in the real world. This is what we want to avoid. So we don't want students to end up in that situation. Thank you.
Thanks, Sophie. Do we have some questions? Yep.
I guess what's been interesting for me is there's been some common messages coming out of the talks. One is about the fact that IRIL and flipped learning are really uncomfortable because of what students coming into, and what's such a big message sometimes is that these things have to be done gradually and very structured, and I think you pointed that out as well. The other part about it which is interesting is that sometimes they also do presuppose existing skill sets.
Yes.
So for example, which is I guess which is something you will probably put in an odd position because this is an elective subject, so you couldn't really necessarily expected your law students to have done an intro to ecology subject before it, or your environment or your science students to have done legal terms 101. But I guess that is part of the problem. There seem to be two common things that are coming up a lot. You know, you're having to ease the students into this through a very, very stepped process, which suggests that there's got to be a lot of coordination across the year. And also you've got to have an agreement with the people before you, that almost like a guarantee that you can build upon the knowledge they already have. It's more of an observation than a question.
Anyone? One last question?
Can I ask you a question?
Yeah, go for it.
Do the students that are bombarded by information, does that reflect a working lawyer in practice, or in terms of a job skill?
Oh, well, actually, yes, because when they're out, not so much for the science students.
No.
But for the law students,
Yeah.
yes, and there's always more legislation, more cases, so that's.
How are they going to adapt when they're out there employed?
I think what in a law subject, there's no way in the world, first of all, you can ever teach them every bit of law to do with the topic to start with. And second, the law that we're teaching them today is actually not the law they'll be applying even in 2 or 3 or 5 years' time. So what we're trying to do is to teach them the skills of being able to find the law, to be able to identify what's relevant to a particular situation, then to come up with possible solutions. So, no easy answers to that.
Graduate attribute type.
Yes, absolutely. Yeah. Yes.
Well done. Thank you. Thank